Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
Good morning, everyone. We have 5 cases on this morning's argument calendar, and we'll begin with number 22-1368, Howe v. Jeffries. And we'll recognize, is it Ms. Zhong? Good morning.
Good morning, Your Honor, and may it please the Court. Assistant Attorney General Lee Jhonnig for the defendant appellants. Before getting into the merits, I'd like to briefly address plaintiff's argument that the Prison Litigation Reform Act does not apply to this injunction. That argument was forfeited because it was not raised in the district court when the parties directly litigated the issue of whether the injunction complied with the PLRA. Plaintiff's brief offers no reason to overlook this forfeiture, and the court should not do so. Even if the court were to reach this argument, it directly contradicts this court's case law and is incorrect as a matter of statutory interpretation. This court held in Kalinowski that the PLRA applies to civil cases brought by persons who have been committed under Illinois' Sexually Dangerous Persons Act. Their criminal proceedings are paused while they are in commitment, and they are vacated only upon discharge from commitment. Plaintiffs offer no compelling reason for this court to overlook this longstanding precedent. And as to Plaintiff Howe in particular, he has continuously been under the jurisdiction of the committing court since 2013. Plaintiffs' limited new evidence that they're trying to introduce on appeal doesn't take Mr. Howe outside of the statutory definition. And even if there were some dispute or some ambiguity as to what these many years old docket entries mean, that's an argument that he should present to the state court, and in fact has presented to the state court, and that's currently pending, as I understand it. Moreover, even setting aside Kalinowski, the PLRA applies to this suit because this suit concerns prison conditions. That term is defined in Section 3626, the very same section that contains the limitations on prospective relief, and this suit clearly falls under that definition. It pertains to the conditions of the plaintiff's confinement, and it pertains to the effects of actions by government officials on the lives of persons confined in prison. That definition is intentionally broad, as the Supreme Court recognized in Porter when it explained that it covers all inmate suits about prison life. It certainly encompasses suits about mental health treatment, which is a frequently litigated suit about prison conditions, as this court recognized in Witzke, and plaintiffs cite no examples of any cases where any court found that a claim about mental health treatment in prison was not a suit about prison conditions. Their only argument is to try to distinguish this suit from suits about prison conditions because it pertains to the purpose of their confinement. But they don't cite any authority in support of this argument and doesn't have any basis in the statutory text. It's contrary to this court's admonition not to add non-textual qualifiers to this particular definition, and again, it's contrary to the Supreme Court in Porter, which recognized that these suits are broad. Because the PLRA applies to this lawsuit, it constrains the district court's remedial power in this case, and it requires that the injunction be narrowly tailored, extend no further than necessary, and be the least intrusive means to remedy a constitutional wrong. Here, the district court applied the incorrect legal standard when it determined that the injunction complied with the PLRA.
Before we get to the dialogue, which is important, about the scope of the injunction, does the department acknowledge you're not contesting the underlying finding of constitutional violations? In other words, the PLRA applies in your view, assume it applies. Then we're going to have a dialogue right now about the scope of the injunction, but I want to make sure when we get into the scope of the injunction, you're not challenging the underlying finding of constitutional violations, correct?
That's correct, Your Honor. We did not challenge the district court's finding that the 3 plaintiffs' treatment that they were receiving didn't comply with due process.
Okay.
And accepting all of the district court's factual findings as we are about what is necessary to comply with due process, the district court's remedy went further than that. That alone shows the district court's legal error, and this court can vacate the injunction on that basis alone. It's most prominently illustrated in the first part of the injunction that requires that plaintiffs receive at least 7.5 hours of core group therapy per week. Now, the district court found that 5 hours was what it called the minimum acceptable number of hours of core group therapy per week. And even assuming that this is equivalent to the minimum that complies with the Constitution, the injunction's requirements of 7.5 hours plainly go above that 5-hour supposed minimum. That mismatch shows that the district court didn't apply the correct legal standard and requires a remand. There were also other parts of the district court's analysis that reflect its application of the incorrect legal standard. Most prominently, the district court's finding of the minimum or acceptable number of hours of therapy doesn't reflect an application of the legal standard for this particular constitutional claim, which is found in Youngberg. That requires that treatment complies with due process unless it is a substantial departure from professional judgment. So finding the limits of professional judgment doesn't complete the analysis. The district court has to consider what would be a substantial departure from professional judgment, and that's the constitutional floor that the district court needs to base its injunction around.
Is that the contours of your argument about why even 5 would not satisfy the state? 5 hours?
There's sort of two aspects to the problem with the 5 hours. The first is what I just explained, that the district court didn't look into what would be a substantial departure from professional judgment. And then the second part is, as we note in our brief, there are several instances that suggest that 5 hours is in fact more than what would be acceptable under professional judgment, or at least not a substantial departure from professional judgment. But the court doesn't need to get into that in order to remand in this case, because even accepting 5 hours, it's plain that 7.5 hours is more than 5 hours, and so the district
I guess I'm trying to understand, if we took what the district court said, which was that 5 would be a constitutionally minimum floor, and we look at what Dr. Colley said and said, okay, it should be 5, not 7.5, would the state continue to have a problem with that part of the injunction?
Yes, Your Honor, because the district court's opinion doesn't say that 5 hours is the constitutional minimum. It uses this term minimum acceptable, but doesn't really engage with the requirements of Youngberg, which is not just to look at what is in compliance with professional judgment, or even what would be the floor of professional judgment, but what is a substantial departure from professional judgment. And I think this court's opinion in Rasho actually illustrates this pretty well. There, the court set very specific numbers of staffing, but the problem is that there wasn't a finding that, well, if you had one less person in one position, would that all of a sudden go outside of what is constitutionally permissible? And it's the same sort of problem here. The district court didn't engage in an analysis about whether, well, if it didn't present any findings that would suggest, well, 4 hours and 55 minutes all of a sudden becomes a substantial departure.
Well, are you going a bit too far? Because we have Dr. Colley on the stand there. And I guess now I'm wondering, do you have any substantive critiques of the method and findings of Dr. Colley?
Well, again, Your Honor, we're not challenging Dr. Colley's testimony or the district court's findings with respect to that.
Then why should we rule in favor of your position? Because it's Dr. Colley himself who said, 1 to 3 hours per session, 2 to 3 hours per week. That's where he gets 5 hours from. 5 hours looks a lot like what happens at Rushville, and that's acceptable. I'm paraphrasing, of course. And so he lands at 5, and then the district court mentions 5. So if you're not criticizing Dr. Colley's method and he lands at 5, what's the issue?
Well, again, Your Honor, Dr. Colley doesn't actually testify that 5 hours is the minimum. He testifies to this range, which, as we note in our brief, goes lower than 5. So the district court's kind of taking 5 as, even if you take 5 as sort of the midpoint of Dr. Colley's range, which is still less than the 7.5 that the district court put in the injunction, that's still conflating what's constitutionally adequate. One example would be 5 hours with doing the analysis to find what's the constitutional minimum.
Let me tell you what frustrates me about this case, and it's why the department hasn't mooted it. What I mean by that is this very dialogue here shows that the department is very quick to criticize the scope of the injunction. It's very quick to carefully parse Dr. Colley's expert testimony when the department itself did not bring forward expert testimony because it missed the disclosure deadline that way. But the department is the one that is running the program and that has the constitutional responsibility to ensure that the program is complying with the requirements of due process, or by extension, professional norms and then due process that way. And why it is that this litigation began in 2014 remains pending is beyond me. I have no idea. And I don't understand for the life of me why the department has not approached the plaintiffs with what your view of professional norms requires, what you can implement, and said, this is what we propose as a collective suite of remedial measures to restore the program to constitutional compliance and to just moot this. I don't understand that at all.
So, Your Honor, I want to be clear that the department has made throughout this litigation a continual effort to increase the amount of therapy provided, not just to these three plaintiffs.
You
but
haven't
to
sent us a letter that said the litigation is moot. We had a series of mediations with the plaintiffs. We've sat down. Here's the program parameters, and the plaintiffs now agree the litigation is at an end. There's no need to come in for oral argument.
Your Honor, I think one of the reasons that the department, or rather the position that the department has taken with respect to making changes to the treatment provided in the program is it wants to ensure that it's providing the same level of treatment for all SDPs. So the department, as it, in the time in between the 3 years between trial and when the district court ruled, it made an effort to increase staffing so that it could increase the amount of therapy for everyone, and it successfully did so. And unfortunately, there's been, at this point, the department has actually lost, it hired 4 therapists just in the short time after trial, and then lost even more therapists than it was able to hire. And the department has continued to make hiring efforts, and in fact hired several more therapists recently. But the problem is that all therapists have to be licensed under Illinois' particularly licensing scheme, which requires extensive practice under supervision, so it can't scale up quickly. That's one of the obstacles.
The case started in 2014. It's 2023.
And to be clear, Your Honor, the department hasn't been providing the same, sort of continual amount of therapy during that entire time. There's evidence in the record that shows how the department was trying to.
So if we remand consistent with your invitation, is the department prepared to sit down immediately with the plaintiffs or go into the district court and make a showing that the program operating along the following parameters today complies with professional norms? And are you prepared to make that showing as opposed to criticizing the scope of the injunction that's in place now?
I can't speak for the person who would be the decision maker on whether to
You
achieve
represent
a
the
mediation,
department
but
in this court.
Yes, Your Honor, and I just haven't spoken with my client about the potential for a mediation, but
It
I would be
seems to
happy
me
to.
that this needs to be resolved quickly.
I understand, Your Honor, and I would certainly propose that to my client. And I'd like to reserve the remainder of my time for rebuttal.
Very well. Mr. Simmons, good morning.
May it please the court. My name is John Simmons, and I represent the appellees James Howe, Jacob Carlisle, and George Needs. The Sexually Dangerous Persons Program at, or SDP for short, at Big Muddy River Correctional Center is an insult to the Constitution and common American decency. It deprives the plaintiffs of their liberty interests while denying them treatment mandated by Illinois law. Without such treatment, they cannot recover. Without recovery, they cannot be discharged. It's basically a life sentence. They can get out cure or coffin. That's what it's been said. The trial court agreed with these sentiments. Plaintiffs have not been convicted of a crime, yet they're being held indefinitely. Mr. Howe's been over 5 years. Mr. Carlisle's over 20 years. Mr. Needs is over 40 years. So while the case has been pending for a bit, these
Mr. Simmons,
gentlemen,
am I right? You've been involved for a while.
I've been involved since the trial. I got appointed to try the case in 2018.
Okay, and has your firm been involved before that?
No.
Okay. Since the trial, have you all had meetings with the department and sat down and said, look, we should share a mutual interest in this? In other words, I hear that I know your problems with the injunction. I got it. But why don't we sit down? My clients have an interest in their constitutional rights being respected, and your clients shoulder a responsibility to operate the program consistent with the Constitution. Let's talk about this.
I have appeared not as a litigant, but just because my client was going to be in Scott County, Illinois, and I was near Scott County, so I stopped in the courthouse to visit with my client while he was in court. And I did make those intimations to another.
But have you guys had meetings?
No.
You talked about this?
No.
I mean, the trial was in 2018. The final order came out in 21. There was some motion practice then, and now we're in 23. And we're
I
still
agree.
bickering about the scope of the injunction.
It's so frustrating, Your Honor. And the comparison to Rushville came up with Dr. Cowley between Big Muddy River Correctional Center and Rushville. And Rushville had the 5-hour requirement. And the state argues that should be at most the standard. But the reality is, at Rushville, they have all-day programming for these folks in SDP program. Or actually, that's the SVP program. All day, from morning till night, they can do things and do classes and whatnot. And there's nothing at Big Muddy River. They're just in their cell. And if their staff, which right now it's one counselor per 40 some odd folks civilly committed, they're just in their cell, locked in their cell. And it's just not right. I mean, this is America. Come on, this is ridiculous. So I share your sentiments that this has gone on too long. It's ridiculous, and this court should affirm the lower court's ruling that 7.5 is a bare minimum. I mean, I can't do the math right now, but if you look at how long.
Problem is, what's the evidence for that?
Dr. Cowley's testimony.
Well, he didn't testify to that, though. He didn't testify that 7.5 is the bare minimum that's
No,
constitutionally
you're right.
necessary. That's the problem. I agree with Judge Scudder's concern. If we remand back to the district court to try again
Right.
on several things, and this lasts longer.
Right.
You know, this goes on and on and on.
Right. There, Dr. Cowley relied on this SOCPIN is the acronym. It's Sexual Offender Civil Committee Network Program. 19 states, the data from all that, and the mean average there was 7.5 hours, and that's where the court got the 7.5 hours.
But under the PLRA, that's not the test. That's the problem. It's all we can do as judges is require that the state provide what's constitutionally necessary. And I don't know that there's any evidence at all that 7.5 hours is constitutionally necessary. Maybe there's evidence that 5 hours is constitutionally necessary. Maybe. But the district court doesn't really engage in that analysis. And there are other problems that the state has identified as well that may have to go back to the district court for the district court to reconsider the scope of the injunction, which drags this on longer and longer while all the time your clients are sitting in jail, not receiving perhaps what's constitutionally required.
Right. The act calls, the SDPA calls for semi-annual reviews for SDPs. My one client, James Howe, hasn't had a semi-annual review in 3.5 years. So, I mean, it's just ridiculous what's going on with these folks. And it should not be.
Has he petitioned the court in the meantime?
Yes, I mean, it just, nothing can happen. He's even filed in the state action, which I'm not the litigant for. In his state action, he's even filed a writ of habeas corpus. And the state just ignores it because he's doing it pro se. If you don't have a lawyer, they're not gonna do it. So, you know, and that's not my case. I can't interject myself in that, but it's just ridiculous. This whole SDPA is crazy. And I tried the case and we won. The court found, and I would ask that you affirm the court's ruling, but at the same time, I know I'm on the right side because these gentlemen should not just be in jail without being convicted of a crime for however long it's been. And
Well,
We're
the
kind of
difficult,
immersed.
it's a very difficult area. Both sides get that, and the treatment is complicated, and it has a lot of different facets to it. But the gravity of depriving somebody of liberty without a criminal conviction, and then at the same time not attending to your constitutional obligations to be able to do that is what disturbs me immensely. And not dealing with that with a real sense of urgency that way. It doesn't mean that the evaluation of a particular individual is going to be easy. I'm not naive about resource staffing challenges. But this case did not start yesterday, and these concerns were not raised yesterday.
well, I'm available to answer any more questions that you may have, and
Okay, very
thank
well.
you for your time.
Thank you. Ms. Jonig, there's some time left for you.
Thank you, Your Honor. I'd like to clarify just a few quick things. First, all three plaintiffs have received semi-annual evaluations and treatment plans in November and December of this past year. And then to the discussion about the plaintiffs' state court proceedings. So Mr. Howe is represented by counsel because he is statutorily afforded that right under the Illinois Sexually Dangerous Persons Act. Any person who seeks a discharge petition in state court has the right to counsel. And it's the state court that ultimately decides whether to release or whether to conditional release or discharge a person from commitment. The record in this case reflects that of the 6 plaintiffs who originally started in this litigation, 3 of them were conditionally released or discharged from commitment during the course of this litigation. The record also reflects a number of other SDPs who are not part of this litigation were then released during the pendency of the litigation, and then an additional approximately 20 sexually dangerous persons have been discharged or conditionally released just since trial. So the obstacles to release here are not entirely are not entirely about the treatment that's provided to SDPs. The obstacles to the ultimate decision maker about release or discharge comes from the state committing court, and all 3 plaintiffs have recovery petitions pending in the state court currently. For these reasons, we would ask the court to vacate the injunction and remand to the district court. Thank you.
Okay, very well. Thank you. Thanks to both parties. The case will be taken under advisement. We'll move to our second case of the morning. This is appeal number 22-1271, Brian Zhong versus the Board of Regents of the University of Wisconsin. Mr. Bourne, good morning.
Good morning. May it please the court. Michael Bourne for the appellant Brian Zhong. This is a Title VII case on appeal from the district court's grant of summary judgment in the Western District of Wisconsin. Dr. Zhong raised claims of employment discrimination and retaliation in violation of Title VII. On appeal, Zhong is requesting that the court reverse the district court's order and remand the case for further proceedings. Zhong was hired as the director of affirmative action at the University of Wisconsin Oshkosh campus. And he was hired in order to be an aggressive agent to change how things were going on campus, to advocate for further diversity in the staff, and to closely monitor all of the university's hiring practices.
Seems
So
like he got the aggressive part right.
that may be true, yes. If he looked at this and he believed there was discrimination happening, it was his job to say something about it and push for changes. So when he saw problems, that's what he did. When he got to his job, he learned about complaints from current and former employees. He saw that there were white employees being promoted that bypassed the normal EEO procedures. And finally, this all came to a head when he tried to hire a Latina candidate for a position in his department that he had the authority to make that decision, only to have his supervisor, the head of the HR department, intervene, ask to re-interview white candidate, and tell him that minorities are not a good fit for HR. So after, his concerns at this point, he'd come to the conclusion that if his job is subject to being overruled by somebody who doesn't want to hire minorities, his job is just nothing more than lip service. So he went to the vice chancellor of his division, who he was supposed to be discussing and advising about these issues, and told him, look, I think the university is discriminating against minorities in hiring and promotions. This is what happened with this candidate I'm trying to hire. And really, I can't work with this supervisor anymore. And instead of taking some action on that, Zhong was fired a few days later.
Did he threaten to resign? The way I understood the facts a little bit different, which is significant here. I understood the facts as him demanding to be assigned a different supervisor, or if he wasn't, he would resign.
Our position is that, well, as I understand the facts, he never said, or I will resign. The distinction is, he put in an email, I can't work with Shauna anymore. That was the name of his boss. He did not say, or what he was going to do, in terms of what he said to the person he sent the email to, the decision maker. Privately, Zhong thought, okay, if I can't get a new supervisor, maybe in a few months, I think I'm going to resign in a few months. But the important thing here is, why did the university fire him? What matters is what the decision maker thought.
Well, yeah, but did he tell anybody at the university at any point that he would resign if he was not reassigned to a different supervisor?
No.
And in fact, it does not appear that Fletcher, to whom he was speaking, understood it that way.
Right, exactly.
Because Fletcher's response was, well, we certainly hope this will work out and we'll come to a resolution. And so it was all about continued future dialogue, not a feeling, at least on the employer's part, that they were being threatened with a resignation.
Yes, exactly. I mean, that's a version of the facts that only came out at summary judgment. But at the time, the decision maker, James Fletcher, said to him, I think we can work this out. And he was thinking maybe if we talk and we all talk together and have better communication, the two of them will be able to work better together. The most striking thing about this case to me is really something that the university has just never had anything to say about. At summary judgment, the university and their witnesses just made Zhong out to be a terrible employee, disrespected his supervisor, butting heads with everybody, just this guy who couldn't work well with others. And, I guess saying he's done with this supervisor is the most audacious thing someone could say. It was kind of their version of events, and that's why the main reason the university says he was fired. But the university has never had anything to say about the fact that the reason he was butting heads with everyone and complaining about his supervisor was that he was making complaints about discrimination. And that's not a reason to fire someone. Those are protected complaints. And I would like to draw the court's attention to just one case that I believe is really dispositive of Zhong's retaliation claim. which is Castro versus DeVry University. In that recent decision, the court, the employee was, this court's recent decision, the employee was terminated and the employer came and said he had volatile, insubordinate behavior, he wasn't cooperative. But then the explanation of this kind of uncooperative behavior from the employer was not limited to, but included protected complaints he had made. You know, an email saying, oh, he's the person that complained about this supervisor, he keeps going over his supervisor's head, he challenges everything as being racially motivated. And that's very similar to what happened here. When Zhong complained about racial discrimination to the chancellor's chief of staff, she understood, she testified that she understood it was a complaint of discrimination, but yet she went to the decision maker and said, yeah, I do think you should fire him. He came in and he was being unprofessional and complaining about his supervisor, and I thought that was insubordinate and inappropriate. When he told his supervisor, he believed she was treating the Latina job applicant differently. She said, I don't appreciate you making this about race, and then went and wrote a negative performance review in which she also said that when he had complained of a pay disparity, that was a job performance concern. And then this performance review was something the decision maker said that he relied on.
Mr. Bourne, can I ask you
yes.
about the scope of the retaliation claim as it comes to us?
Yes.
Okay. So I think it's pretty clear to me that at summary judgment, your client argued that the people of color don't fit in the HR department. That comment that was advanced by Mr. Zhong to Mr. Fletcher in the March 6th meeting is a core basis of the retaliation claim. But you also argue in your brief that there's other dimensions to it, that Mr. Zhong was more broadly complaining about advancing concerns that underrepresented employees were being treated unfairly in the workplace, including with respect to pay and what have you. That's the part of your argument that it did not seem clear to me that you appropriately preserved below.
Sure. I guess a two-part answer to that. As I recall, the argument that was made in the district court about retaliation specifically, I don't think it had much to do with that comment made by Zhong's supervisor. It was focused on timing and the fact that the point was explicitly made that the fact that they commented on his protected complaints was evidence of retaliation. So specifically the the pay part being in his performance review, the chief of staff saying that it was unprofessional for him to come and complain. I'm wondering if I'm missing part of your question.
No, so here's what I thought the core of his argument on retaliation was on March the 6th, I told James Fletcher that Shauna Quather made this completely inappropriate comment about people of color not being welcomed in the HR group. They're not a fit in the HR group. On March 7th, the very next day, Mr. Fletcher made a decision to terminate the plaintiff and then sought to give appropriate notice and approvals within the university. Okay, I thought that was the core of the retaliation argument, that this is not a situation where there's been a number of intervening events that create some confusion or some questions about causation in the timeline, that the time fit here is very tight.
Yes.
He puts this in the meeting on March 6th, and then on March 7th, Fletcher made a decision to fire him, therefore allowing a jury to find that there's retaliation in the termination.
And I would agree with that, in that the timing is absolutely a large part of this. The matters I've been discussing now definitely expanded the discussion on appeal, which I believe we have every right to do as appellants. But yeah, I do not mean to de-emphasize the.
Well, you
crucial timing.
weren't his counsel at the time either,
Right.
right? So you've reviewed the record. That could explain it too. But the way that I saw it presented to the district court was primarily around the comment about people of color not fitting in HR and the timing of that comment to Mr. Fletcher.
The timing of Zhong reporting, making these complaints.
Yeah, I'm glad that you've been asked to clarify because I understood it quite differently, that his complaints were much broader than that. His complaints and began as early as March 1, not March 6, but March 1 about the treatment of the Latina candidate and his superior's decision to bypass his hiring process and insist on interviewing a white candidate when he had determined that the Latina candidate was the one to hire who was more qualified in his estimation. And so the complaints of that process, not just that one comment. And then also the idea that he mentioned to McQuillan, we've got a bigger problem here because you have this other employee, Sean Crawford, who made these exit interview comments. So can you clarify the retaliation as presented to this district court? Then again, we can affirm on any basis we have a de novo review here. But how broad was the retaliation picture painted?
I agree with what you are saying, both in terms of what was presented to the district court and how I see it on appeal and how I have attempted to present it on appeal. There was basically a few days at the beginning of in early March where Zhong went from just kind of sharing some general concerns to making all kinds of complaints, like you referenced, and they got very direct and explicit about the fact that they were racial discrimination. The timing, it just kind of built over several days, so the timing is still very close in time. It's not that there was some intervening, cause in between the 1st of the month and the 7th of the month. But that is the picture as you're explaining it is how I see it.
Mr. Bourne, was it during
Yes.
that March 6th meeting when he delivered, I have to look back at the record regarding whether it was an ultimatum or not, but was it during the March 6th meeting when he said, I won't work with her any longer?
That was when he said, I won't work with her any longer.
I mean, that's kind of an ultimatum, right? I mean, you do what I want or I'm not going to work here anymore. And the university kind of said, well, you're not going to work here anymore.
Well, I mean, I think the issue is, one, he didn't say, or I'm not going to work anymore.
But there is an issue of insubordination here, right? You would agree with that?
I think what it comes down to here is that the jury had a right to decide that. That shows that this is such a fine-grained issue where he's both making complaints that are protected complaints, very forcefully making these complaints, and also requesting a new supervisor in a pretty forceful way also, which is not protected. And it's all happening at once, and it really just should have gone to the jury to be able to sort that out.
Okay, Mr. Bourne, you want to save some time for rebuttal?
Yes.
Okay, very well. Mr. Kilpatrick, good morning.
Good morning, Your Honors. May it please the court. My name is Stephen Kilpatrick, Assistant Attorney General with the state of Wisconsin, representing Appellee Board of Regents of the University of Wisconsin System. Here to argue that the district court got it right and this court should affirm. University of Wisconsin Oshkosh did not fire Dr. Brian Zhong because he is Asian or of Hmong national origin, and it did not fire him as Director of Affirmative Action in retaliation for complaining about race discrimination. There are some key points that I'd like to make today. Dr. Zhong, employee, he was insubordinate to his direct supervisor, Shauna Keither, and that was shown through the leadership council situation. The leadership council situation is not a thing that was overlooked. Mr. Fletcher made that one point of purpose. That was a reason for firing of Dr. Zhong.
I'm really confused by that, I'll have to admit, because the record shows that she was forwarded all of those emails when he was submitting those draft policy reviews as early as 2 weeks before the meetings.
Right.
And we don't have anything in the record establishing that he was supposed to follow some other course. And so it seems to me, I'm not quite sure where Ms. Gunther is coming from or the university is coming from saying that she was not kept apprised.
It is confusing, Your Honor, and it took me a while to figure it out as well, is that she was aware that he was working on policies. There was a veterans policy and some accessibility policies. What she was not made aware of is that he was going to put it on the agenda of the leadership
She was
council.
forwarded all those emails where that was happened, where he had submitted them, and then where it was gonna, he got the reply, it's gonna be on the agenda. She received each of those emails.
I think what she received was his emails about the policies, but I do not believe she ever received emails that said, I am putting these on the agenda of the leadership council. And that is what was the concern of UW Oshkosh, is that Dr. Zhong, went and put that on the agenda for the leadership council without consulting her. She was aware he was making these policy changes, but to put it on the leadership council agenda was something that she said that he did not do.
So it sounds like there's a dispute there, and that it's material because that was one of the key reasons the university gave, one of 3 key reasons the university gave for his termination.
I do not agree, Your Honor, and the reason is that on this appeal, Dr. Zhong is attempting to dispute proposed findings of fact that the university made and proposed to the district court, and he did not dispute them in response. Document 49 is the final replies of the University of Wisconsin-Oshkosh. What happened, proposed findings of facts were made. In response, Dr. Zhong is required to dispute them with evidence. So either when I'm saying there is no dispute and when the district court made a mention of dispute by Dr. Zhong on pages 2 and 3 of the district court decision, the district court recognized that Dr. Zhong either said no dispute to many of these proposed findings or simply put in his dispute a statement without evidence supporting that. And that's why I am saying that many of these purported disputes are not disputes. They're not genuine disputes made by Dr. Zhong. And so I urge the court to look at those documents. In the brief, you would notice that I mentioned the facts, citing the facts from the district court and to our proposed findings and the paragraphs that would show that there was not a dispute made at that time. I agree, Your Honor, that this is de novo review, but it's not a second chance.
But you know, we did look at it, and there are times the district court seems to be wrong. Adjacent to the example you just provided, for example, the district court says that Zhong didn't provide support for his contrary view that he committed Gunther to doing a presentation without her knowledge. And the district court very explicitly says he doesn't provide any evidence, affidavit or otherwise. And then you go back and you look at Zhong's proposed for findings of fact, and in his response to the proposed findings of fact, don't cite an affidavit, but his brief in opposition to the motion explicitly disputes it, and then cites to his proposed findings of fact, which cite to his affidavit. So how can the district court say there was no affidavit?
Well, that may be an instance where the district court didn't look at his own, Dr. Zhong's proposed findings, but it does not take away from the other aspects of the reasons for his termination of employment. Again, Dr. Zhong was insubordinate, leadership council incident, disrespectful, telling McQuillan that she had a lack of knowledge about affirmative action. She was insecure, a lack of leadership. This was about his supervisor, Keither. Went behind her back to try to attend meetings with the chancellor and trying to get on his cabinet. McQuillan thought that he tried to reverse the change in reporting structure that was made by the university prior to his hire. And that goes to his ultimatum. The district court decided to call it an ultimatum. We disagree on whether what to call it. I will call it an ultimatum. Opposing counsel will not. But this is what he said in an email, Dr. Zhong to Fletcher. I'm done reporting to Shauna. That was in the email. Later on, he says, I either report to you or to the chancellor. The other option is report to another vice chancellor. That sounds like an ultimatum to me. And that's what he put in his email to Dr. Fletcher prior to being terminated. Also, Your Honors, he wrote a poor investigatory report. There was little analysis and parroting witness statements. Those are from not only what McQuillan thought, but Fletcher as well. He misrepresented Keither's involvement in the training and compliance officer hiring. He had said that she was preventing the hiring of a Latina candidate. That's not the case. It is undisputed that she was sick, Ms. Keither, during the interviews. She saw that there was a recommendation by Dr. Zhong to hire the Latina candidate. She simply wanted to review those two candidates, the final two candidates, and never put a stop to it and never prevented him from hiring her.
Can we go back to the poor performance report that you just mentioned? The investigation
Yes.
report. Should we consider the fact that he was never given any direct feedback on that report, his first report in the job, and then terminated without a performance plan as evidence of pretext? Or should we be looking at those two facts, the lack of direct feedback on that report and the lack of performance plan, as something else?
Well, it certainly isn't pretext. What it is that Dr. Zhong made that authored that investigative report. It was criticized by McQuillan and Fletcher. Rather than approaching him directly, what they did was contacted University of Wisconsin legal counsel and had a training on how to write investigative reports made. And that was made for Dr. Zhong's benefit and other persons' benefit as well.
And that was 3 months later or so. It was in March.
It was.
It was in March.
Yeah, I think you're right. I think it was in March.
And so when they then terminate him, they terminate him based on the poor report that happened before the training.
Well, yes, there was training after the report, but prior to that, he was given templates and prior investigative reports.
But that seems to be a dispute too. So you dispute that that's a dispute because Dr. Zhong says he was not given any of that. So how do we not find that that's a material dispute?
I don't believe he denies that he was offered templates and prior examples of investigative reports. He's denying that he received, quote unquote, a training. And that is true. He did not receive a training prior to writing the investigative report. He was given training afterwards, but prior to that, he was shown this is how we want these reports to be written. And he did a bad job with that. One of the reasons on appeal is that Dr. Zhong says that now there's this standalone national origin discrimination claim that wasn't raised below, that he's focusing on complaints about poor grammar in that report. Yes, it's true that there were comments made by McQuillan and Keither that there was poor grammar in those reports. But there was also a lot of complaints about the poor analysis that was done and the parroting of witness statements in the report. So it wasn't an investigative report that was heavy on analysis, and that was the big complaint by University of Oshkosh.
Go ahead.
Do we have any evidence in the record that after the training, he prepared another investigatory report that was deemed unsatisfactory to the university?
No, he only did one report during his 5-month tenure there at the university, Your Honor.
Is there anything in his employment documents that require the university provide him training if he's unable to satisfactorily complete the report? In other words, when he took the employment, is there any handbook or anything along those lines that exists that says, if you do a bad job on a report before we fire you, we'll provide you training, we'll send you to classes, is there anything like that in the record?
No, there's nothing like that in the record. Dr. Zhong did not have any expectation that there would be training. Keither did, again, his supervisor, was surprised that he was terminated prior to receiving any performance improvement plan, but he was not entitled to any performance improvement plan.
Mr. Kilpatrick, can I ask you about the retaliation claim?
Sure, yes.
Why is the timing here of the March 6th with what went down in that meeting and the March 7th decision by Mr. Fletcher that I'm going to go seek the requisite approvals or give the notices to terminate Mr. Zhong? Why isn't that enough to create a jury question? Because I totally understand your position that the ultimatum is insubordination, but there just seems the plaintiff has put forward evidence that in the March 6th meeting he conveyed Keither's statement about people of color not being welcomed in the HR group. Isn't that just the jury should just sort this out?
I disagree, Your Honor, and I believe that the district court attempted to explain that is because timing isn't everything. Of course, there is going to be a retaliation claim made out if an action is taken after a report of discrimination, but that is not enough. And I agree with the district court here.
Do you agree that Mr. Zhang's statement conveying Ms. Keither's comment or alleged comment, I know she contests that she said it, but that's protected, correct?
That would be likely be protected activity. I know that the district court.
Right. So right on the heels of that statement that he makes to Mr. Fletcher, perhaps because of another reason too that you call insubordination, takes action to terminate him. And the reason I want to press you on this is because, as you know as well as we do, that you don't have to have a singular cause here. In other words, a mixed motive kind of termination here, or mixed motive retaliation. It's plenty to get to a jury, and then maybe the jury will find that Mr. Zhong is not in any way credible on this. Maybe to the contrary, they'll find he's quite believable. It's the whole point of a trial.
Well, Your Honor, for the retaliation claim, right, the law requires a but-for causation here, and the way that Dr. Zhong is trying to argue this, first it was, may I continue with my thought?
Yeah, go right, please.
Is that it was confusing as to the retaliation claim on how it was presented before the district court as to how it is now.
We said last year in Lessive that on but-for causation, what but-for causation means is only that the adverse action would not have happened without the activity.
Right.
You know that. So that
Yes.
just means that there can be more than one cause.
Right. And what I was trying to get at, I think what the district court said, is that without more, that may be enough, but here there is more. Here the employer can come back with non-retaliatory legitimate reasons for the adverse action, and those are the same ones that were raised in response to discrimination.
It doesn't erase or eliminate Mr. Zhang's point that he says, hey, look, I had a meeting on March 6th. I told this guy something he probably didn't want to hear of Keither's comments, and you know what? On March 7th, he canned me.
Right.
The timing is awfully close. The only way it could get closer is if the step to seek approval to terminate occurred actually on March 6th. I mean, the law would get ridiculous.
Right, but there, in addition to the reasons, the non-discriminatory reasons, there are also non-retaliatory reasons. But in that same conversation, the meeting and the email, there was the ultimatum. The ultimatum, if you don't restructure, I'm going to quit. So
Isn't that precisely the question for the jury to sort out?
no,
It all
because
happened in the same meeting.
here the burden shifts to the employer. The employer can show that there are non-retaliatory, legitimate reasons for the adverse action, and that's what we're saying here, is that the same reasons for non-discriminatory reasons are also non-retaliatory reasons, and I apologize for going over.
No,
Thank you for
we're
your
asking you
time.
questions. You don't have to apologize. Thank you very much.
Thank you, Your Honors.
Mr. Bourne, you had a little time left.
Thank you. Just like to quickly address a couple of things that came up were both the leadership council situation and the supposedly poor investigatory report. They are not, the leadership council situation is not confusing. It is clear that he sent her the emails, that he was submitting it. She got the agenda with his policy proposals on it. The thing I would like to mention is that these things are really evidence of the university's, really the employers and the university's witnesses' lack of credibility about the reasons they gave for the termination. With the leadership council situation, the record clearly establishes that the supervisor was well informed about the submissions.
Mr. Bourne, let me ask you a
Yes.
question about that, follow up Judge
Sure.
Scudder's question. In order to show pretext, do you have to show that the university's reasons for firing your client were false? In other words, in this meeting, your client says, let's up the ante. The client says, I'm being discriminated against, and by the way, if you don't pay me $5 million and allow me to report directly to the president of the university in Madison, I'm going to quit. And the chancellor says, you know what, you're fired for insubordination. Should that go to a jury? Because the timing there, it's right during the meeting. He says, you're discriminating against me, and if you don't pay me $5 million and allow me to report right to the chancellor or the president of the university, I'm going to quit. And the chancellor says, you're fired. And now he files a lawsuit and says, well, it happened during the same meeting. Should that go to a jury?
The question I would ask, which is what is relevant here, is did that decision maker believe that he was really requesting $1 million and
Well, if he
would
said
leave
it, why would he not believe it?
People don't always take seriously what somebody says to them.
Well, do you have any evidence in the record that the individuals responsible for firing your client didn't believe that they fired him because of the ultimatum?
Yes, the evidence is the decision maker's testimony that when Zhong went to him and said he needed a new supervisor, he says, well, I don't really know what he meant. All I could do is tell him that I sincerely hope that we could work things out. And then he reflects more in the deposition. He says, I thought at the time that if we all talked about it, the two of them could learn to work better together. This is really, you hear about the honest belief rule a lot, and it comes up in favor of employers. Well, what's good for the goose is good for the gander. He privately was planning to leave in a couple months if he couldn't get the new supervisor. But the employer doesn't make a decision, can't say that they fired him based on something that they didn't know about and didn't even think was true. That is just really clearly shows the lack of credibility here. And I see I'm over my time. Thank you.
Okay, very well. The court will take the case under advisement. Thanks to both counsel. We're going to take a 5-minute recess and come back with our 3 remaining arguments. Okay, our third case of the morning is appeal number 22-2516. Adebaye versus the South Suburban College. And Mr. Brand, good morning.
Good morning. In place to court.
Absolutely, go right ahead.
My name is Baldwin Brand, counsel for the appellant, Ms. Sanjay Adebaye. And one of the central questions before the lower court was whether or not there was a causal connection between the protected activity she engaged in and her ultimate termination. The district court erred when it found that there was no reasonable jury could agree that there was such a causal connection, and took that decision away from the jury. Ms. Adebaye presented evidence, the record will show, that the timing of her termination was in fact suspicious as defined by the circuit. Specifically, she was fired within 3 days of an Illinois Department of Human Rights pending meeting where she was to discuss the discrimination and retaliation that she had suffered at the hands of her employer, South Suburban College, and her president, Donald Manning.
Mr. Brand, what's the, I'm glad that's where you took the argument here, but what do we, I think that's her best fact if there was more. So I think you're right to emphasize it, but what do we know about the meeting? Who attended, what was on the agenda, what transpired, etc.?
Well, what we know is at least as late as November 2018, the supervisor who in fact recommended that she be fired was aware of a complaint that had been filed with that agency regarding discrimination and retaliation. And so just prior to the meeting that you just mentioned, she received an evaluation from the supervisor where she received a meets expectations January 18, 2019. She was fired less than a month later for failing to meet job expectations, basically. And so when you couple those together, we construe the inferences in favor of the non-moving party as required under the law. It's clear that...
Yeah, I think it's fair to say you can infer that the meeting related to the complaint.
Correct.
Right, because why would the Illinois Department of Human Rights just randomly show up for a meeting? So that's fair. You can connect it to the prior complaint. But don't you need to know more than that?
Well, I think that the inferences, and that's why I think in this case the inferences are very important. The inferences, if drawn in favor of Ms. Adebaye, is that they were connected primarily because she had just received a meets expectations in her job performance January 18, 2019, and just prior to participating in this meeting with her employer, she was terminated. And so a reasonable jury could find that the two were related.
And let me ask you
there was a
this.
causal connection.
The complaint had been pending since Manning was president, but would this IDHR meeting in February 2019 have been Stokes's first meeting, the first meeting to take place under Stokes's leadership?
Correct.
Okay.
And at that meeting, again, obviously, she had made complaints about the university and her treatment there. And so,
Does the record establish that Stokes was, do we know for sure that Stokes was present at the meeting?
actually,
Like in
I don't think
in the discovery record, could we look and see, there's no question Stokes attended the meeting. Where's that at in the record?
I don't believe the record specified that, largely because of the reasons the defendants presented in their motion for summary judgment as to why there was no retaliation. So, for example, they simply said that because employer has a right to demand a very high standard, let's say, and exceeds satisfaction on a job evaluation, that alone, kind of circumvented this retaliation claim. And our response was we don't deny that an employer has a right to demand an exceeds satisfaction. The issue was the supervisor switched completely from January 18th, where she's saying that she met these expectations, and then relied on issues that predated her tenure under Donald Manning, where she's specifying certain deficiencies occurred. And so when you look at the timing of the participation of the meetings and the parties involved, and the fact that Stokes undoubtedly was noticed of the complaint that was filed, a reasonable jury could look at the array of evidence and find that there was retaliation.
Is
Not
it-
only, oh, go ahead, Your Honor.
It seems to me some of the things that Stokes pointed to happened under Stokes's tenure. Is your position that nothing happened under Stokes's tenure that Stokes could actually point to and had personal experience with?
I know that there was an issue with the communication pathway, for example, chart, but I believe that arose July, August-ish of 2018. And I know it arose prior to her evaluation where she's saying that she met expectations, which is the critical issue here. But outside of that, I don't recall any of those issues, quote-unquote, performance-based issues arising under her independently. And in fact, because most of them arose, even though most of them arose under Donald Manning, it's interesting that he even testified in his deposition that he had no issues with her performance. And so, given these facts, as well as in the declaration where Stokes is pointing out additional contradictory positions that was taken by, Adebaye was pointing out additional contradictions that was taken by Stokes. Again, we contend that the jury should have made the determination. And
Mr. Can I ask you one? You mind if I ask you one more question, then you can save some time. One of the aspects that made the review of this difficult for me is when you try to look at this, what's disputed and what's not disputed. The district court made some observations at the outset of its opinion about what it saw as being violations of the Rule 56.1 requirement with respect to the way the respective statement of facts were put together. And the district court said that your client really just didn't comply with the rule. And so there are many aspects of the versions of fact, or the statement of facts that the district court lays out that are probably quite contrary to your client's view of what happened. But because your client didn't properly comply with the 56.1 requirement, that's what the district court was doing. Are you challenging any aspect of that on appeal?
well, I would, simply because I don't believe the defendants raised that argument, but more importantly, the facts, the district court actually included in its summary the critical facts that are necessary to warrant a reversal of its decision. So, for example, the district court recognized and accepted as fact that the meets expectations was in the record, and then the defendant switched to you need and exceeds after the fact, which is a critical point. And so when you look at the critical evidence that, you know, between the timing as well as the contradictions in positions, for example, with Stokes, that alone we contend would be enough to raise an inference of causation.
Okay, very well. You want to save the remainder?
Yes, Sean.
Okay, good. Is it Miss Brooke?
Ms. Brooke.
Good morning.
Good morning. May it please the court. Julie Brooke on behalf of the defendants, South Suburban College and former President Donald Manning. The district court properly concluded that the defendants were entitled to summary judgment on the Title VII retaliation claim. Under the but-for standard, the issue is whether or not the existence of this meeting that was to take place in February of 2020 would have caused her termination. And in fact, there's no evidence in the record to support that argument. As this court has repeatedly stated, suspicious...
I'm wondering how much more do we actually need under our case law? If what Ms. Adebaye is saying is there was a meeting scheduled, and we can all agree the meeting was about her complaints of discrimination, you know, and then we draw inferences in her favor, what more do we actually need to know about the meeting if the termination takes place a day or two before?
The most important factor that this court needs to know is, in fact, whether or not Dr. Stokes was aware of the meeting, was aware of the reasons that the meeting was going to take place, and was even going to be attending the meeting. And in fact, as someone who...
If she's president of the college, does she need to be at the meeting? And if she's president of the college and had been handed a file as early as November, you know, what can't we infer she knew that one of her only, 5 vice presidents had a pending discrimination case? It's a small college.
Your Honor, there is no dispute whatsoever that Dr. Stokes, when she became the president in November of the year before, was aware that Ms. Adebaye had filed a charge of discrimination. But in fact, was she aware of the day-to-day minutia of what was going on in that charge of discrimination? The record doesn't say. I can tell you, as someone who was present at that meeting, that Dr. Stokes was not at the meeting. And did she have knowledge of the meeting? I honestly don't know. It's certainly no evidence is in the record. Now,
Is that where we would need to then draw an inference, not in the college's favor, but in Ms. Adebaye's favor? And if not, why not?
because under the law, the college has to provide a legitimate non-discriminatory reason for its employment decision. And in this situation, they have provided a declaration from Dr. Stokes in which she's provided a laundry list of all of the reasons why she recommended to the board that Ms. Adebaye's contract not be renewed. The reason for that timing is because the contracts are renewed in June of that year. So procedurally, the Board of Trustees needs to vote in February as to whether or not they're going to be offering candidates contract renewals. So at this time, Dr. Stokes recommended that both Ms. Adebaye and another employee of the college not have their contracts renewed. So that is the reason why that happened at that time. The burden now shifts to Ms. Adebaye to prove that that was not Dr. Stokes' motivation, that the real motivation behind her decision was a desire to retaliate against Ms. Adebaye. And under that scenario, Ms. Adebaye has failed to meet her burden because she has not presented any evidence to the court. And the district court was correct that there was no basis for any court to determine that Dr. Stokes would have appreciated any significance to this meeting whatsoever. So simply based on the fact that she had a pending charge of discrimination, is an employee now immune from any adverse employment action simply because they filed an action? Absolutely not. This court has said on numerous occasions that employees who commit misconduct, even while there's pending charge, can still be terminated, and that's what happened in this instance.
What is your response to Mr. Brand's argument that many of the things Dr. Stokes pointed to that she was dissatisfied with happened before she gave her the rating meets expectations, and her explanation that I now want my vice chancellors to exceed expectations happened after the meets expectations rating?
So if you look at the declaration of Dr. Stokes, she identifies how she had numerous meetings with Dr. Stokes leading up to the recommendation to terminate her employment or to not renew it. So there was constant communication between Dr. Stokes and Ms. Adebaye about her performance. So Ms. Adebaye would have known that Dr. Stokes did not believe she was performing up to the standards required of supervisors that are at the vice president level. Is it possible and permissible under this court to treat supervisors to that higher standard? Absolutely. In Title VII cases, when we're talking about sexual harassment, it's common that this court holds a supervisor to more of a vicarious liability, a strict liability, as opposed to the regular employee who was held to a negligent standard. When you have situations where there is racial harassment, if the racial harassment is committed by a supervisor as opposed to a regular employee, they can be held to a higher standard. So essentially what this court is telling people like Dr. Stokes is that yes, you can hold your vice presidents to higher standards, and simply meeting expectations is not enough, and that is something that you can decide that we're not going to recommend a renewal of a contract because you're simply not performing good enough. You're performing adequately, but you're not performing good enough. I mean, I think that situation happens all the time with a professional sports team, where you have the coach of the team, or you have a player who is adequate and they're doing okay, but in the minds of the organization, they expect a lot more performance-wise from their coaches and players to justify the higher salaries. It's the same situation here. So based on that, there's really nothing that this court can go to that's present in the record to show that the reason given by Dr. Stokes for the recommendation not to renew is in fact a lie, is pretextual. So essentially that is the only evidence that the plaintiff has presented on that issue. She's argued also that there is a computer forensics exam. That was not an adverse employment action. Simply having the police officers come there is not enough. She's argued that there are similarly situated employees who are treated more favorably. There's no evidence really in the record that has been developed to show that those individuals were similarly situated. Her second argument.
I do have a question about that, because she's pointing to a number of leaders at the school who were accused of sexual harassment, who were not terminated. They are not vice chancellors like she is. They don't report to the president like she does. But again, it's a small college. There are only 5, if I recall, vice chancellors. Why can she not, under our case law, point to other leaders who report to other people and her argument be beyond the realm of similar conduct, but this is more egregious conduct that was treated more leniently? What's impermissible about that as a comparison?
I think that the argument itself makes sense, but if you were to look at the developed record in the evidence, you will see that Ms. Adebaye made a number of accusations without actually having any foundation. She wasn't present for the decisions that occurred. She was not responsible for the investigation of the allegations, and in fact, President Manning, who was present at the time, he has said that I wasn't even involved in those decisions. A lot of these people ended up resigning beforehand, or the individual who was found to have engaged in misconduct never appealed that decision to my level, so I never even had a chance as college president to weigh in. And it's important to know that President Manning had already left the college 3 months before the recommendation to eliminate her position or to not renew her contract. So he would not have even weighed in on that decision itself. So simply the issue of removing her computer, which occurred under President Manning, that wasn't an adverse employment action. The only adverse employment action occurred after he'd already left. So Dr. Stokes, who was the person involved in that decision and that recommendation, had absolutely nothing to do with any of the comparator evidence that Ms. Adebaye has presented to this court. And so for that reason, we would request that the decision of the district court be affirmed.
Thank you. Mr. Brand?
Your Honor, I'd just like to add that the record is clear that Ms. Adebaye was terminated based on stale evidence that was drummed up at or around the time of the meetings that she had scheduled with the Illinois Department of Human Rights, and following the complaints that she made against the college related to retaliation and discrimination. And based on that, along with the other evidence, for example, the comparative evidence that the court just referred to, as well as the fact that her office was raided by armed police officers, even without considering the affidavit, which on the one hand, appellees rely on the declaration, on the other, the court seemed to equivocate on whether to or whether not to. There's enough evidence in the record that this case should be decided by a jury with respect to the retaliation claim.
Okay, very well. Mr. Brand, thank you. Ms. Brooke, thanks to you. The case will be taken under advisement, and we'll move to our fourth argument of this morning in appeal number 22-1502, the United States versus Tobias Diggs. Yeah, it's Miss Eisman, right? Yep, good morning.
May it please the court, Vanessa Eisenman on behalf of Tobias Diggs. This case should be remanded for a new trial during which Mr. Diggs' wife, Devin Adams, should be allowed to invoke her spousal testimonial privilege. Again, we currently have a circuit split, with this court being the only court on the side that recognizes the joint participant exception in the context of the spousal testimonial privilege. The four other circuit courts to have decided this issue have decided to reject it in that context. So there's a current circuit split. This court could resolve that circuit split by reconsidering and rejecting the joint participant exception. The case that is most recently from this court is 40 years old. So for those reasons, it's kind of ripe for reconsideration. Besides which, that case, Clark, the rationale that it gave for continuing the joint participant exception in this context is really mooted by Trammell, and Clark just doesn't really acknowledge that. Trammell, as this court undoubtedly knows, decided to vest the opportunity to invoke the spousal testimonial privilege only in the witness spouse, therefore eliminating the prospect that the defendant would simply enlist his spouse as a co-conspirator without any fear that she could testify against him because he could just invoke the privilege. Now that's only vested with the witness spouse. Therefore, there's no more fear of that happening. And that was Clark's primary rationale. Even though Clark came after Trammell, it still said that that was the primary reason why we needed the joint participant exception. And again, all of these other courts to have decided this issue after have not been persuaded by that. The most recent one is the First Circuit in the Pieta-Monteo case. Really did a nice job of laying out why Clark's reasons are no longer really applicable, and deciding to join the other three circuits that have rejected that exception. So again, I think this is a prime example and a good case for this court to take another look at that and reject that exception just in this context, not in the context of the marital communications privilege, just in the context of the spousal testimonial privilege. If this court decides not to do that, our next argument is that, okay, even if you don't want to deal with Clark right now, it doesn't apply to Ms. Adams because she was never a joint participant. If you look at all of the cases that we talk about in our briefs, you look at the Van Duren case, you look at Clark, you look at Trammell, you look at Westmoreland, in all of those cases, there's no question that the spouse was a joint participant, right? The only question is really kind of when does it kick in, or should we recognize it in a certain context? There's no doubt in Trammell, she was a drug co-conspirator. In Van Duren, she was the illegal alien that was transported over the border. In Parker, the wife helped kidnap and murder the victim.
Is that the test, though? No doubt.
No.
No, because the issue here is abuse of discretion, right? I mean,
Yeah,
if we say that Clark is still good law and
Yep.
there's no reason to overturn it, the issue here is one of abuse of discretion. Did the district judge abuse his discretion in viewing the witnesses and viewing the testimony? We don't get any of that. I mean, that's why it's such a high burden, and it's not, so I'm not sure that comparing it to cases where that there's no doubt that the spouse participated, as to this case where admittedly it's close, okay?
Yes.
It's close. But what about the standard?
Yeah.
Tell me about the standard.
No, that's a good point. That's a good point. I'm not trying to say that it has to be a no-doubter, and you're absolutely right. The first issue that I mentioned about whether this court should continue that exception, that's de novo. We're not on that anymore. We're on abuse of discretion. But we still have the trial testimony, and that's what we need to base this on, okay? And the trial testimony, page 33 of our appendix, Miss Adams says that she didn't even know what was going on until she started Googling. So she gets this frantic call from her husband saying, I just hit a J-spot and you gotta come get your car because it's all over the news. She is frantic. She doesn't know. There's absolutely zero evidence, whether it's at the Santiago proffer or anywhere else, that she knows anything about this robbery.
But she's not his wife at the time, and she doesn't hang up the phone and call the police, or I think that was part of Judge Feinerman's finding. She then takes actions which are consistent with helping him. Whether he's right or wrong, okay, that's not the test, but that's what he found.
Right.
And how do we conclude that that was so wrong that it was an abuse of discretion based on this record, where admittedly there are certainly two sides of this coin.
So there are two things that she does, and that the District Court Judge Feinerman touched on. First, she texts her dad and
She says, I got to go get my car, right?
she says, would it be possible for you to take me
But
back?
she wants to go get her car.
She says she's frantic, she doesn't know what's going on, and
Her boyfriend just told her
just
what
wants
was
her
going
car
on.
back. That's her
He just
trial
robbed a
testimony.
jewelry store.
We don't have anything else but that. She's frantic, she gets this call, she wants to get a car back. She says absolutely nothing about wanting to conceal that car. That's where the inference kicks in, right? She says nothing about concealing that. Maybe she wants to go get the car from the cops and thinks the car is with the cops. We don't know. That's not in the trial testimony. The trial testimony is that she was frantic. She didn't even know what was going on. She wasn't even sure by J-Spot he meant jewelry store until she started Googling it. And that comes into our next argument, that even if you think she was a joint participant at some time, she certainly wasn't when he said the J-Spot, or made the initial J-Spot call. But getting back to the other one, she contacts her family members to see if they could possibly give her a ride back. That's all we have in the trial testimony. She was frantic, she didn't know what was going on, she just wanted her car back. What also is in the trial testimony is that she decided not to do anything about it because she didn't want to be involved. Once she had an idea of what actually was going on, she decided she did not want to be involved. So for this court to say that, or for the district court to say that she is definitely a joint participant, she's a conspirator, just by asking if somebody can give her a ride back to Chicago, that is an abuse of discretion. And even if this court does not agree with that, again, the biggest thing that came in her testimony was the J-Spot call, the initial call. She doesn't know anything about it. This is the first she's hearing about it.
I think abuse of discretion is a tough, high standard. I think an even tougher, higher standard is harmless error. So can you address that
Absolutely.
more than you did in your brief?
Sure.
Given the phone records that connect Mr. Diggs to the area of the robbery, to Atlanta, where the man whose name I don't know how to pronounce was offered watches, to the testimony from the other girlfriend that she was given the car. What's your response?
Yeah, absolutely none of that is a wife getting up on the stand and telling the court that my husband confessed to a crime. Again, the test is not sufficiency of the evidence. We have not made a sufficiency of the evidence claim here. The test is whether the offending testimony has a substantial effect on the jury's verdict.
Isn't the corollary test whether the other untainted incriminating evidence could lead to a conviction?
Not could lead to a conviction is overwhelming, is I believe what this court
Yes.
says, is
Yes.
overwhelming. Not sufficient evidence, overwhelming. And I don't think it's overwhelming because, again, this is a wife's testimony. We have a privilege just because of the importance of this, right? The Supreme Court says sanctity of marriage, we got to protect this. There is nothing more unseemly than a wife getting up on the stand and saying, my husband told me he did it, right? That is powerful. The government even calls it super powerful evidence. The government spends 5 pages talking about her testimony in its closing statement. Clearly, the government didn't even think that her testimony, clearly the government even thought that her testimony was very important. The phone records, again, that was disputed at trial. It was a big dispute about was there enough evidence to connect that 901 number to Mr. Diggs. So that was disputed. There was other circumstantial evidence that came in about, cell site records. Again, this is all circumstantial evidence. The only direct evidence of a confession came from the wife. The only direct evidence that he was seen afterwards with stolen jewelry came from Silk's improper hearsay testimony that was injected that I'm not going to get a chance to discuss. So anyway, for all of those reasons, we would ask that whichever basis this court wants to do it, that it remand the case to the district court for a new trial where Ms. Adams is allowed to invoke her privilege. Thank you.
Okay, very well. Okay, we'll hear from the government.
May it please the court, Georgia Alexakis representing the United States. The defendant's convictions should be affirmed. Those convictions were based on properly admitted evidence, including testimony from defendant's then girlfriend, now wife, who the district court correctly found was a joint participant in the offense and thus subject to this circuit's long-standing recognized exception, the joint participant exception to the spousal testimonial privilege. Defendant's convictions were also based on an overwhelming amount of additional evidence that Judge Jackson Akwumi nicely recapped during counsel's earlier argument. All of that evidence, setting aside the J-spot call, that so-called J-spot call, linked the defendant to the robbery. That includes the Lexus SUV that was used to commit the robbery and defendant's undisputed multiple connections to that vehicle, as well as all of the phone-based records that showed the defendant in contact with the robbery crew in the months leading up to the robbery and on the morning of the robbery, that showed the defendant 1.5 miles away from the jewelry store, which was a 35-minute drive from his home, and that he was at that location on the morning of the robbery and for the precise duration of that robbery, supporting the government's theory of the defendant's phone being used as a walkie-talkie system to facilitate the robbery.
So I have a question on this. The harmless error aspect of the case does not seem all that easy to me. And the reason is not because of what you just said about the strength of the evidence that the government marshaled to show that Mr. Diggs committed this robbery, but rather under the governing standard for harmless error on a non-constitutional error that, as you well know, comes from the U.S. Supreme Court in Kadiakas, that we have parroted over and over again. We have to look at whether we can say with fair assurance that the error did not sway the jury. When I read the government's closing argument, it quite understandably featured Ms. Adams' testimony and then used everything else that you're pointing to right now. I get why you are, to reinforce that. It used everything else as corroborative, as making sense of that. But doesn't Ms. Eisenman have a fair point that in front of the jury, what's doing all of the anchoring for everything is Ms. Adams' testimony?
Judge, I understand the question, and I understand the persuasiveness of defendant's argument. I have spent a lot of time thinking what would this trial look like if Ms. Adams had not testified.
Okay, I'm really happy. Thank you for saying that. Okay, that's exactly what I was thinking in preparing, and I've convinced myself, maybe you'll persuade me I'm wrong, that's not the right question. That isn't the question under the Kadiakas standard of review, and it's not the way we have articulated it. In other words, you can't do that. That's precisely the error that I think I've made.
You mean, I want to make
In
sure
other
that
words, you need to look at the way the case was presented to the jury, okay? And then ask yourself whether you can say with fair assurance that, the verdict was not substantially swayed by the error in question. Put differently, it's not about a dialogue that you and I can have right now in the Seventh Circuit
Right.
about the strength of evidence. Rather, we need to kind of transport ourselves back to the jury room, mindful of the way the case was presented. And that's what brings me back to the way Mr. Parente argued it in closing argument. And I'm not faulting him for that. It had a very powerful anchoring effect.
I understand, Judge. What I would point you to are the same things that I looked at when I was preparing for argument today. And certainly I looked at the government's closing argument. I also looked at the opening statement where Ms. Adams' testimony is not mentioned at all to the jury. And then I looked at the rebuttal.
Well, that's probably because they weren't sure that she was going to hit the stand, right? I mean, usually that's what government lawyers do, is they don't want to preview testimony that actually doesn't take place.
I can't disagree with that based on experience, Judge Kirsch, but when I'm putting myself in the position of what was the presentation to the jury, to put myself in the jury's shoes, I know that in the opening statement they didn't hear anything about Adams. They heard no promises about a confession that would have been conveyed to the defendant's wife. When we get to the rebuttal, I want to emphasize that now we're in the government's rebuttal. It's a 20-page rebuttal. There's a one-sentence reference to the J-Spot phone call. The rest of the rebuttal is dedicated to the other evidence. And then going back to the closing argument, yes, there are 5 pages, approximately 5 pages that are spent talking about Ms. Adams's testimony. Before you get to Adams's testimony, there's a long discussion about the text messages and the phone evidence. And then there's an insertion of Mrs. Adams's testimony. And there's 5 pages on the Lexus. And then there's 24 more pages going back to the phone evidence. And I believe what the prosecutor says on page 1380 of the transcript, the 901 number proves he's the robber. So from the government standpoint, that phone evidence was what had a substantial influence on the jury's verdict. Because Adams's testimony, as powerful as the government concedes that it is, was also subject to strenuous attack from 2 defense counsels in the course of cross-examination, undercutting Adams's, exploring all the biases, all of the reasons why she would have to testify against her husband, and that was laid out for the jury quite clearly throughout the trial, given the presence of another girlfriend, of the mother of another child for the defendant. And so it's not a situation where, yes, the government I can't change the words of the prosecutor during the closing argument. He did refer to it as powerful evidence. But I think when viewed in context of the entire trial, it's clear that that was not that piece of evidence that had a substantial influence on the jury, given, and going back to the standard, other untainted incriminating evidence that, in the government's view, was clearly overwhelming.
Can I get the benefit of your, let's go to the Trammell point.
Yes.
We haven't grappled with the effect of Trammell on Van Drunen with the kind of rigor and thoroughness that you might expect. And you'd say, well, this case presents that opportunity, so grapple with it and affirm it, is your point. That way. What is it, though, about if you take the recent decision that Judge Torwea drafted for the First Circuit that way? That seems awfully powerful to me as a substantive matter.
I think one thing that's important to note about Pineda-Mateo is that Pineda-Mateo spends a solid 3 pages explaining why Trammell does not actually answer the question that the defendant says Trammell in fact mooted.
Well, that's because of the way that's because of what went on in the 10th Circuit. Because of the joint but keep going. I think it's the fruit of the way the case was litigated.
I understand, but if defendant's point, and I think this point comes up multiple times in the reply brief, is that Van Drunen's logic is no good because there's no reason to have a joint participant exception post-Trammell, I think Pineda-Mateo would say actually that's still an open question post-Trammell.
Oh yeah, I agree. I totally agree with that.
Great. So then in terms of how to answer that open question, I think if you look at Van Drunen, Clark, and I think Byrd, which is the third set of cases, I think Byrd, all of those cases together do a nice job of justifying why the joint participant exception should persist post-Trammell. And I think, again, Van Drunen and Clark make the point that a criminal should not have this assurance that he can enlist a spouse to aid in the criminal enterprise without fear of creating another potential witness. And I find that logic persuasive in a case like Van Drunen and Clark in here, where the marriage post-dates the criminal activity.
So that's interesting. That's the reason you give. You're not going to marital harmony. That's not where you started. That
is not where I started.
Right, and I think for a reason. The reason you're not starting with marital harmony is because, perhaps, you tell me I'm wrong, that Trammell puts that rationale on extremely shaky ground. Because what Trammell is doing is saying, let the marital harmony judgment be made by the testifying spouse.
And I do find more persuasive the truth-seeking function, the truth-seeking rationale. And I think Byrd, in particular, has extremely strong language that would support that conclusion. Byrd addresses head-on this argument that shows up in the Second Circuit case in grand jury subpoena. It shows up in the First Circuit case regarding this idea that you're creating an uncomfortable scene, that there's discomfort in a world in which you're compelling one spouse, to testify against another. And Byrd head-on addresses that and says that, yes, courts may want to avoid the naturally repugnant sight of a spouse revealing marital confidences on the witness stand. But again, this circuit went on to prioritize, quote, the truth-seeking function of a trial. And it said that it, quote, should not be outweighed by oversensitivity to embarrassing testimony. And so I recognize the analysis, the compelling points in the analysis in Pineda-Mateo. But at the end of the day, when I look at what the Seventh Circuit has said about that exception in Van Drunen and Clark and Byrd and Total, I also see a compelling rationale. I see a compelling rationale that has addressed all of the points that the other circuits have raised. I think it's worth noting that the circuit split is not quite as dramatic as I think defendant wants to present it. We have a vast majority of the circuits who have not weighed in on this issue at all. And so I think that should be a factor as well when considering the need for this circuit. I mean, I would posit that there is no need for this circuit to overturn its longstanding exception to the this joint participant exception to the spousal testimonial privilege. I see that my time is up. I don't know that I had a chance to, I want to make sure that there aren't any other questions that the court would like for me to address.
Okay, thank you very much.
I'd ask that this court affirm the district court's judgment. Thank you.
Ms. Eisenman, we'll give you 2 minutes on rebuttal. So it's a difficult case. There's no need for anybody to hurry.
Okay, thanks.
Go right
I
ahead.
really appreciate it. Just if I could address a couple of points, maybe ending where you all left off. Just that, Trammell did a really nice job, I think, of kind of doing a deep dive into this exception and talking about the differences and talking about, it seemed at one point in the opinion like the court was maybe even going to just throw it out altogether. But then it talks about the importance of the spousal testimonial privilege. And it says that the way it wants to balance the truth-seeking function, too, which is important, of a jury trial, is by vesting that ability to invoke the privilege in the witness spouse. It says that is the proper way to balance it. Granted, I have never argued on appeal that Trammell makes an absolute bar. I realize that was argued in the district court. I have not presented that argument on appeal. I'm not saying Trammell says you can never have this or it shouldn't be up to the circuits to decide. But Trammell does a really nice job of saying this is how it's properly balanced. Let the witness spouse decide. Let her decide if there's something in the marriage that's worth saving. Let her decide if she wants to testify. And in some of these cases, we have a witness spouse saying, I'll testify. There's nothing left to this. I'm divorcing this guy. We're done. That is absolutely not what happened here. As the government says in its closing argument, she's in tears. It's uncomfortable for everybody. This is exactly the type of case where the spousal testimonial privilege should be applying.
When you pivot over to harmless error, the point that the government's making is, yeah, it was all framed and anchored around Adams because transcript says what it says that way, but the evidence is overwhelming. When you just set aside, there's just no question that you can put him in Hinsdale, you can sync up with the cell site and the other phone records that they're effectively using these phones as walkie-talkies, or you permit an inference, and it just gets worse from there. They connect him to the car, they put him in Atlanta. At some point, you're piling up evidence that Mr. Diggs is in a very difficult position.
I understand that. But again, I think Your Honor did a really nice job of making my argument for me. It's significantly less persuasive in the mind of the average juror without that testimony. The end. Super powerful evidence, according to the government. If you want me to address the individual pieces of evidence, I'm happy to do that. This was really well argued by both sides in the district court. The judge did a nice job. Counsel vigorously cross-examined all of the witnesses regarding the 901 phone number, regarding the cell site, saying it actually never pinged to the cell tower that was closest to the robbery. It pinged to one in the area, but not to the closest one. There was evidence that the brother also had access to the car and could use the car on occasion. There was Mr. Diggs's brother. So there were lots of different, really good, vigorous cross-examination. And I think that, combined with just looking at how powerful the wife's testimony was, you can't say harmless error here. Thank you so much for the extra time.
Okay, very well. Ms. Eisenman, I see here you were appointed by the court
Yes.
to represent Mr. Diggs. You have our thanks for a job very well done to the government as well. The case was very well briefed and argued, and we thank both parties. We'll take the appeal under advisement.
Thank you, Judge.
We'll turn to our final argument of this morning, appeal number 22-1641. Live Face on Web LLC versus the Cremation Society of Illinois and others. Mr. Borsche, good morning.
May it please the court, my name is Jim Borsche. I represent Cremation Society of Illinois, Illinois Commission Director, and Catherine Sullivan Frideris. The district court erred in this case by denying my clients the reimbursement for the attorney's fees, expenses, and costs they incurred in defending against plaintiffs' claims for copyright infringement for 5 years before they were dismissed with prejudice. There's no dispute over the fact that my clients' prevailing parties prevailed in all the claims the plaintiff brought. The standard for awarding fees and expenses is a strenuous one, and that is there's a very strong presumption for defendants that they get awarded attorney's fees and costs for prevailing in these kind of cases to incentivize defendants to defend these claims and to deter predatory litigation. To overcome that presumption, there has to be clear and convincing evidence that the defendant did something in the case worthy of punishment, according to the Congregation of the Passion case we cited. District court abused its discretion because there was none of that evidence here. And the discretion this court has in these kind of circumstances is very confined.
Mr. Borsche, can I ask you a question as to, I don't know what's going to happen in this case, of course, but it seems to me that if the district court made an error here, the district court made an error when it disregarded the presumption in favor of your client by saying Google intervened. I mean, to me, that's like saying, well, a jury intervened and decided the case, and after the jury intervened and decided the case for the plaintiff, the defendant, or the plaintiff walked away, and so there should be no fees. But if the district court got that wrong, then does the district court have to evaluate the Fogarty factors all over again with the strong presumption in favor of fees? Or is that something that we should do?
I think you should do that.
Why?
Well, because I think that's part of the analysis here is I think the courts have said the Fogarty factors are still in play, but before you get to those factors, you have to overcome the very strong presumption, which in this case, there's no evidence in this case that my clients did anything wrong. And that's where I think, so the Fogarty factors come into play, but first I think you have to get through the presumption that in this case was not met by the plaintiff in this case. I mean, there's simply, the district courts had two reasons for denying fees. One is he said there was a change in the law. That's false. I mean, Google even says, we are not changing the law on fair use. So all Google did was apply existing fair use law.
Well,
so
if there was a change in the law, I mean, that happens all the time in litigation. I mean,
and that's a
risk that both parties take. That's why they litigate.
Correct.
I mean, sometimes there's a dispute on the fact, right?
Right.
Sometimes there's a dispute on the law.
Right.
That's the reason for litigation.
But I agree with that, Justice Kurtz, but the issue is Google says we are not changing the law. So the issue here is this court also said the defendants did not prevail because of their defenses. That's also false. I mean, if we had not pled fair use, which is a affirmative defense you have to plead, if we had not pled that, the plaintiff wouldn't have the argument here. So we did prevail because of our defense in the case. So the lawsuit in this case we have shown, even under Fogarty, was unreasonable for a number of reasons. The suit was time barred. He sued Ms. Frideris personally on no basis to do that. They also claimed these ridiculous amount of damages, almost $500,000. Before this lawsuit was filed, my clients had licensed from the plaintiff this very same software for less than $400. And then they asked when they filed a lawsuit, we want $400,000. Where is that coming from? So they also alleged, despite saying that their code was stolen by Tweeple, they alleged that our infringement was willful. There was never any evidence to support that. So they have a number of factors that their lawsuit was improper. The motivation to file the suit was not to protect their code, was to try to extort money from my clients, a lot of money.
Mr. Borsche, what I think the challenge is for me is as I hear your argument, it sounds exactly like the argument you made to Judge Blakey.
Well, that's true.
Right, and the case, this is a case where the litigation went on for quite a while.
Yes, yes.
There was a lot of discovery, but one thing that was continuous all along was the district court judge. There weren't multiple reassignments of the case to different district court judges. So he sat there the whole time, had a very close vantage point to it, and at the end of the day said, Mr. Borscht, it's not that I don't understand you. I don't agree. I'm going to exercise my discretion. So given the standard of review here, I mean, isn't it heavy-handed for us? Given all of these factors, they're all thrown in the hopper. District court has a very close vantage point to it all. I'm just not going to award fees here.
Well, I think that's the problem with that reasoning is it goes against this court's standard, and that is the very strong presumption. Because the district court found there was a change in the law. That's false. Google did not change the law.
I mean, you're saying that based upon why did the U.S. Supreme Court grant review in Google in your view? Why did they grant certiorari?
Well, there was obviously some issues that they wanted to address, Judge. But
Right.
in their opinion, they say we are not
Okay,
changing
so
the law.
while fair use with respect to code is unsettled, while Google is pending before the U.S. Supreme Court, the case remains litigated in the district court.
Correct.
Google comes out and you're able to say, oh, I read Justice Breyer's opinion. It doesn't look like the law changed. Okay? You don't know that ex ante.
But Google was never cited in this case before that ruling came down. And before that ruling came down, the plaintiff wanted out of this case. We cited
Hold on, say it again.
The plaintiff wanted out of this case before Google. I mean, they say, well, you take a walk away. They sued my clients in Pennsylvania, which the judge found was vexatious.
What difference does that make? What difference does Google make? I mean, in here, that's why I asked you the question. It's a similar question to what Judge Scudder asked, because if the judge properly applies the presumption, the balancing test begins here, okay, in favor of fees. And in order to not get fees, the plaintiff needs to come to here. When the judge says, no presumption here, the judge starts here. So then there's just this tipping of the scales in favor of no fees. So my question is not whether the judge got the weighing of the scales wrong. It's whether he started from the wrong place by saying, well, this was a close case, and at the end of the day, defendant won. That to me does not, that happens in litigation, and that's not the test.
Correct. And I agree with you, Judge. And the problem here is what he found was that Google actually levels it. And there's no precedent to say a change in the law somehow disrupts the presumption.
But if we find that way, shouldn't we send it back to Judge Blakey to say, start here and weigh the Fogarty factors, and maybe he's going to come out in the exact same place he did before, but he's going to do it by applying the strong presumption in favor of fees.
I had no problem with that. Because the problem here is he found that the change in the law was somehow a disruptive factor to the presumption. And the fact is, there's no precedent for that anywhere. To say that because the law changes or the facts change from what you presented when you filed the case, that somehow the presumption should be done away with. Because that's the risk. I mean, they filed a lawsuit in Colorado against another defendant, Integrity. They prevailed. What did they say? Well, fees are easy to get in these cases. They're presumed to get fees. Why shouldn't the same rebound against them here? We cited the Rockford map case, which found recently, district court, on almost the same facts, with the same damages sought. The plaintiff was a copyright troll. Its damages were unrealistic, and awarded $400,000 in fees against the plaintiff in the same kind of case, where you didn't have a situation where they sued my clients in another venue.
I don't know if we could say it's the same case when there was the statute of limitations issue there, the clear losing issue there. But you raised a second issue I'd like to turn to before you're out of time, which is the Copyright Act and Rule 54. And, is it at all clear that if costs have been rejected under the Copyright Act, that they then can be awarded under Rule 54? And I'm wondering, are we in a position to fault the district court for leaving that argument alone as underdeveloped when you did not answer that question about the interplay between the two? You did cite Rule 54 as a basis. I saw that. You did cite it as a basis. It was kind of buried in a case cite for costs, but did not explain whether the judge, in your view, could still award costs under Rule 54 if the court found that it shouldn't be awarded under the Copyright Act.
So just one thing about the statute of limitations, we did have the same defense here. The difference is here, the plaintiff dismissed the case before the judge ruled in summary judgment on that issue. So we did have a limitations argument. In fact, I think we have a better one than that case. But the issue on the cost is, we did present as an alternative 54 or the Copyright Act. And you're not bound by either one of them. If the court doesn't find fees under the Copyright Act or costs in the Copyright Act, you can still get fees under Rule 54. There's no exclusive remedy there on that issue. So we asked for fee costs under both of those provisions. The district court denied that, and there's no reason that's even a higher standard in the costs than is for fees. So we believe, we certainly met the 54 elements about the Copyright Act elements. I think my time is up. But
Okay, very well.
Thanks, Judge.
Mr. Santuri, good morning.
Good morning, Your Honors. May it please the court. I'm Ryan Santuri. I'm here on behalf of Live Face on Web. I do want to, this is a unique case. This is, neither side cited a case where somebody sought fees when a party dismissed the case because they reasonably believed there was a change in the law.
That's actually a very good point. Can you cite me to any case in the Seventh Circuit or any other circuit that says when there's a change in the law or the facts during the litigation, which results in one side abandoning the case, the presumption in favor of fees goes away?
Well, Your Honor, no. In fact, I can't cite you to a case that says that I can't cite to a case that's ever looked at fees under 505 when a party dismissed a case pursuant to Rule 11, period. Now, I know that there was a lot of discussion about the judge eliminating the presumption of fees, but he said the opposite.
I know he said the opposite, but if Google had come out the other way and the defendant walked away from the case and settled with you for $500 or whatever, you would have sought fees, right? You wouldn't have walked away and said, well, we understand that Google changed the law and therefore that's why we won the case. That's why cases are litigated in the first place. That's like saying, in my view at least, what's different than saying we took the case to trial as the plaintiff, we lost, okay? And rather than filing post-trial motions, we walked away. And because we walked away after the jury decided against us, the presumption in favor of fees for the defendant goes away. What's different here?
I don't think anything's different. I don't think the presumption of for fees ever went away. I think that what the district court did here is he looked at the O'Brien versus Knott case and he said, hey, since a bunch of these earlier Seventh Circuit decisions, this court in O'Brien versus Knott recognized, yes, there's a presumption versus fees, but the Kurtzang Supreme Court case specifically says, hey, you still have to look at factors.
But the rationale of O'Brien actually supports their argument, because the rationale of O'Brien says there's this strong presumption in favor of fees, so defendants are not under pressure to abandon a meritorious defense and settle. That's what they did here. They stood on their meritorious defense and didn't settle. And Google, whether you take Judge Blakey's word for it or not, Google comes out, and I accept your representation that Google comes out and you walked away for it. So the rationale from O'Brien says that there is this strong presumption of fees, and it fits right all square here because they didn't walk away. They stuck with the litigations. How do you respond to that?
O'Brien said, yes, there's a strong presumption of fees, but that's not the only thing that carries the day. You have to look at the factors, and here the judge found that none of the factors favored under abuse of discretion.
That's not true. How many lawsuits has your firm filed on behalf of this particular client claiming copyright infringement?
A number of them.
Over 100, right?
Our firm has not, I don't believe, but I know that the client has filed over
hundreds.
Yes, sir.
Okay, and Judge Blakey found that weighs against your client, at least a little bit. And then there was the frivolous lawsuit in Pennsylvania that weighed against your client.
Nobody found that case frivolous. He said that he believed that was partially vexatious, but he also acknowledged that was a different, that in that case, that judge recognized that was a different claim from here, and that was a case that was dismissed with each side bearing its own costs and fees. But ultimately, on the factor where he looked at whether this was frivolous or vexatious, he did not find it to be. He said, yeah, sure, there's some evidence that the defendants cite that says that, but I still don't see that carries the day. He also found that given the exact same case that I presented at trial in Colorado and won with the jury and through post-trial motions that mirrored this case. Nothing was different between that case and this one. That didn't suggest it was objectively unreasonable, and I do think that is where the courts have really been looking at. That's sort of the primary factor, is it objectively unreasonable? And here there was no evidence to suggest that. What I think from our position is, and I think that this is what the judge really focused on, is what is a litigant to do if you recognize that what you reasonably believe is a significant change in law that moves your case from likely success, like we had in Colorado, to likely failure and potentially getting hit with fees against you? Aren't you supposed to, under Rule 11, notify the court of the change in law?
No doubt.
And so,
but how does that save you from the presumption? That's like a motion for summary judgment. The judge decides a law. Maybe the judge denies summary judgment, but decides the law in a manner in which you're clearly not going to win at trial. And so the plaintiff walks away from the case. How does that say? Like, you understand my problem that I was discussing with Mr. Borsha? I'm afraid the judge should have started balancing the factors from here, but the judge started from here. And if the judge started from here, maybe the result is different.
Well, I don't think that anything about the scenario changes the presumption. So but I believe, and this is exactly, and we have to take the district court at his word. He says, I recognize that there's a presumption, but that's not the only thing I look at, and that's what the O'Brien case said. And I do want to point, I noticed when I was preparing last night, I made a mistake in my brief when I said they didn't cite to anything after that Kurtzang decision. They did make a reference to the design basics versus Kearson's, a case that Judge Scudder actually wrote the opinion. That was a case where it went with the home plans, where the court did acknowledge the same thing, that Kurtzang says, hey, yes, there's a presumption, but we also have to consider the factors. And here, that final factor, not only did the court find that this wasn't objectively unreasonable, but that final factor about we have to consider the balancing the Copyright Act and promoting the rationale for it. Here you have essentially, is it really balancing the benefits of the Copyright Act, that fourth factor, when a party says, Judge, we believe there was a significant change in the law that kills our case.
Can you pause on that for me, Mr.
Sure.
Santuri? So explain to me the best you can what aspect of the Supreme Court's reasoning in Oracle you think affected a substantial change in fair use law.
Sure. So in leading up to and recognize that the Federal Circuit had found against fair use, strongly found against fair use, and it was picked up based on the prior standards set by the Supreme Court, and this was reversed. And I think that really Justice Thomas, in his dissent, makes the best argument for me, because he goes through and talks about how this is not transformative in the way that we have always talked about transformative before. This is when our prior precedent says you can't cut out the heart of the copyrighted work, and here the admitted evidence in the Google Oracle was that they could have copied like 170 lines instead they copied 11,500. In the Sony case, going back to the old Betamax case where they talked about fair use in a different in the context of motion pictures and TV, it was presumptively unfair if you were using it for commercial purposes. So here, the way I saw fair use lined up beforehand is we have commercial use by a party. They were using this in their advertising, which is presumptively unfair. They were using it in exactly the same way as how it was used by my client's customers, so it's not transformative. They took all the code that they took was more than 50% of the lines, and without those lines, the program doesn't work. Those were all factors that lined up with fair use, in my view, as somebody that does, that does IP law a lot. And here, when we get to the Supreme Court, suddenly the most important thing by the Supreme Court is somehow like a public policy argument on, hey, look at all the consumers that would be impacted if you did this. It doesn't matter that Google saved itself millions, maybe billions of dollars. It doesn't matter that they took far more than they needed purposefully. And so especially in the context of the first case ever for source code and fair use, we had Java code, 11,500 lines of Java code intentionally copied to avoid paying for it, not fair use. Here, I'm going to have to tell the jury they copied a few hundred lines of my client's code. It was the heart of their code, but they copied, but it was being copied on their website, and have to say that somehow that's different from the Google case. And so I think that between Justice Thomas's dissent and also Professor Nimmer, who writes treatises on this, he specifically, I noted in my brief that all the factors were basically reordered by this one decision. And so, and I think I briefly said that there were more than 50 law reviews at the time. I looked last night, it looked like there were several hundred now that have talked about the impacts of this change.
Let me ask you a question. Should we be at all concerned that in analyzing the Fogarty factors, the district court never once mentioned Catherine Sullivan Frideris, who your client sued on an individual basis just based on the fact that she registered the websites?
Sorry, I wasn't sure if you're done. And I don't believe that has any impact, Your Honor. No, that was the subject of motions to dismiss that were denied. I mean, ultimately, she was identified in public documents as essentially the owner of the website for purposes of how websites are registered. And as the owner, the allegations were that she had control of it and had the control of the code on it. Certainly, had there not been a change in law, I'm sure that would have continued to be litigated, but I don't believe that has any impact on the question of fees here.
Okay, very well.
I apologize
Thank
for
you.
going over my time, Your Honor.
No, that's okay.
Thank you.
Mr. Santuri,
Yes, sir.
I think your time had expired. Oh, I'm sorry. No, thank you very much. It's Mr. Borsha. I think your time had expired, but we'll give you a minute for rebuttal. We kept Mr. Santuri a little bit longer.
I just want to bring up one thing you already brought up. Ms. Frideris never should have brought in the case. In fact, they learned in discovery that she was not the owner of these websites, and yet they kept her in the case for years. The other issue I want to address is Mr. Santuri suggesting this was a Rule 11 issue. It wasn't at all. They didn't even suggest in the district court it was Rule 11. In fact, they said in the district court they could distinguish the facts in Google from this case. Because in Google, less than 1% of the plaintiff's work was copied. In this case, the plaintiff alleged 40% of their work was copied. So they even said in the district court that Google was factually distinguishable. The bottom line here is, the presumption, the very strong presumption applies here. There's no exception they have ever shown to prove, and therefore their district court should be reversed or remanded to allow district court to properly evaluate the factors given the presumption. Thank you.
Borsha, thank you. Mr. Santuri, thank you. We'll take the case under advisement. That concludes the day's arguments, and the court will be in recess.